will be going back to the North Gauteng High Court now. It seems we have those live visuals back. Let's go live.
Post-traumatic stress disorder does not mean I am anxious because of the sentence. It means because of the events I suffer from a post-traumatic stress. It is absolutely connected to the events, not to his fate after the events. And that caused him, what happened there caused him the post-traumatic stress order. That he has elevated levels of anxiety, including symptoms and signs of social phobia, agoraphobia, and panic disorder. Professor Scholes is of the view that the mental health of the accused has deteriorated since 2014, apart from a worsening of his clinical conditions, inter alia the PTSD, the depression, and the anxiety. The accused has become despondent and disinvested, leaving his future in the hands of God. In layman terms, he describes the accused as broken, and in his opinion, he would hospitalize the accused if the accused was his patient. Professor Scholes also states that the accused has strong feelings of unworthiness and self-loathing. The accused has become isolated and fearful of venturing out in public. He has a feeling of disconnectedness. We say that the state tried to discredit Professor Scholes on the basis that he was biased and there's no substance. We say it's significant that the state did not challenge or seek to rebut the veracity of the test done and his clinical observations in that regard. He sought and obtained consent from the Health Council, that's the HPCSA, as he wanted to protect his objectivity. Professor Scholes explained that at the time of his report in 2014, he held the view that there were two Oscars. The one a superstar and tall, and the other a vulnerable, fearful, disabled person of less than 1.5 meters in height without his prosthesis. That was from a professor appointed by the court, not by a defense witness. And that was his report that was not challenged in this court. It was Exhibit QQQ. We all had the right to ask to cross-examine witnesses if we wanted to, and none of us exercised that right. Professor Scholes explained in this court that there is now a third Oscar, a broken man. Professor Scholes' evidence in this regard was supported by the evidence of Pastor Nell, which was not challenged by the state. Pastor Nell testified that he had visited the accused in jail, and I must say quite frequently, and that he observed him to be a broken man. Pastor Nell also testified that the accused was showing strong emotional feelings for the pain caused to the family of the deceased. Pastor Nell also testified that should the court so decide that the accused could be used for charity work in the church, which would entail sport and nutrition training and education for underprivileged children. Pastor Nell explained that the church, the schools, and the accused were excited about the project. That's important. Whatever the court's going to do, it tells us something about the accused. That's the point. He wants to put back into the society, notwithstanding everything that has happened to him. He wants to put back. We say in further pursuance of community upliftment, the accused has also obtained employment as an external consultant at Twin City Development Pty Limited, and that's to manage the Early Childhood Development Project. And that copy is before the court's Exhibit A. You will see it. It's the first 1,000 days in a child's life that is so crucial. And that's of course to do with underprivileged children and how to give assistance during that period. But the full document is before the court. It is evident from the above that the accused is desirous to contribute to social upliftment as advocated by restorative justice. In addition to the above, we submit with respect, my lady, that the following factors should be taken into account. He's already served 12 months, and we say that the impact of the 12 months imprisonment on him was harsher than 12 months spent in prison for another offender. We're not getting to a point to ask for privileged treatment. We're stating a cold fact. When you send someone to jail, for whatever the reasons, for whatever the sentence, fact is that a disabled person in jail has a more difficult time. You can say he's not exposed to a cell with many people in. But we know there's also the concept of segregation, where you're on your own and you sit on your own, you get up in the morning on your own, you go to bed on your own. You don't go to the dining room because you can't mix with the other guys because you're a risk. You eat in your cell. You do everything in your cell. You're not out. You get 1 hour a day out in a courtyard, a concrete courtyard. It's punishment. We understand it. And it's something that you must do. But it does not mean that it's easier for him. It's not easier. It's, in fact, if you read anything on segregation, you would see that it's really something that could amount to torture, but we don't say that the department tortured him. That's not what we say. We understand because of his vulnerabilities, disability, because of his high profile, that they had no choice but to do that. That is so. There's no criticism. But factually, that's a consequence of his incarceration. That's what we said in paragraph 56.1, my lady. We talk about solitary confinement as that has been described as a form of torture. We refer you to the United Nations Human Rights Committee, what they say about it. We also refer to Professor Scholz's report, where he explained that psychological stresses such as isolation could be as clinically distressing as physical torture. But we say, my lady, despite the harsh impact of imprisonment on the accused, he has completed all rehabilitative components of his sentence with excellence. The rehabilitative programs that the accused completed were part of his sentence plan as a result of a comprehensive risk and needs assessment as contained in the sentence plan of the Department of Correctional Services. These programs are designed to correct the offending behavior and enhance the offender's social functioning, preparation for release and reintegration into the community. The programs the accused successfully completed are the following: New Beginnings Program, Restorative Justice Program, Crossroads Program, Anger in, Anger Out Pre-Release Program. Copies of the successful completion of the rehabilitative programs are annexed and marked. It's in the bundle to you. I think it's a waste of time to read it out to you, but you will see when you go to the conclusions every time that it was with excellence, that he motivated other people, that he was doing so well, and that you could see there was an eagerness to do well. That's the accused he wants to put back. He's done wrong and he wants to put back. We say in addition to the programs above, the accused also attended the following individual therapy sessions: its assertiveness, communications, conflict handling, relationships, problem solving, self-development and stigmatization. Insofar as any suggestion is that he does not accept responsibility for what he has done, you will see in the reports that before he was released that there's a column for that, and that the view was expressed that he indeed accepted responsibility for his deeds. That's not the accused saying, it was the department saying that. Therefore, on 5 June 2015, the Correctional Supervision Parole Board approved the accused for release under correctional supervision on 21 August 2015, being a date after serving 1/6 of the sentence. And I may say up to then, when you receive the sentence in terms of section 2761I, unless you do something wrong, you qualify and you were released after serving 1/6, which would have been a 5-year sentence, 10 months. Didn't happen in the accused place. In his situation, he was told, pack your bags, you're going home, you sent all these things home, and then 2 days before there was a complaint, a petition, and the minister said that he did not take the petition into account, but coincidentally on the same date, he then decided that the provision must be looked at again, and a different interpretation was given, and he had to wait for the parole review board and then the parole board again, and he sat an extra 2 months. Now that has not happened to anyone else before, and the difficulty in understanding this, his release was well publicized by the media long before the time, 6-8 weeks before the time. Why wait till the last 2 days to do it to a person? That in itself, when you know you're going out, you're sitting there in segregation, you're sitting in a place where you want to get out, You want to do your correctional supervision. And just at the last minute, so to speak, you say, you're going nowhere. You've sent your things home. I know we told you can go. I know the parole board found that you could go, that you qualify. You're staying. You're the first one that's going to be considered to apply a new interpretation. Whether that interpretation is right or wrong is not the question. It is the unfortunate timing of that. It was a long time before that you could look at that. When his release was published 6 weeks before the time. Why not look at it then? And say, wait, before you get excited, before we tell you to go out, we want to reconsider. You're the first one, you're the guinea pig, you're the first one, we're going to reconsider it. Not in this case, 2 days before. We say that the accused has almost spent 4 months under correctional supervision at the time of the SCA judgment. Thereafter, from December 2015, as part of stringent bail conditions, he agreed to submit himself to even more stringent conditions than the correctional supervision conditions. During this time, he was subjected to countless false alarms. I remember he sent us every time, so there's a photo. I'm sitting in my house, the alarm went off, I'm not there. There's a problem with that alarm, but it's happened, and it caused him a lot of stress. We say that the decision to broadcast his trial live, it had, of course, its benefits, but let's look at the accused. How did it benefit him? And the resultant media frenzy it has created. It resulted in a trial by public opinion that will continue to haunt the accused long after the conclusion of this criminal process. No other accused has ever had to endure this level of publicity, misinformation, and character assassination premised on a version that he had direct intent to kill the deceased, notwithstanding the fact that that version was correctly rejected by the trial court. Despite the fact that the finding remains that the accused did not want to kill the deceased, or did not even foresee the possibility of her, the deceased, as opposed to that of a perceived intruder, the accused case is still portrayed in the public domain as an example of gender-based violence. And that hurts him, because he was a person opposed to gender violence his whole life. And now suddenly when there's gender violence and you open a newspaper, his face is there. You see representatives standing for a fight against gender violence. They attend his trial as if he wanted to kill the deceased. As if he had direct. Nowhere along the line would you draw the line and say, enough, enough. This man in his mind had no gender violence intent. It had nothing to do with, it's the same, I drive in my car, I make an accident, happen to be a child or a woman in the other car. How's that gender violence? It's not the consequence, it's the intent. He did not even enter his mind. On the contrary, it was excluded in his mind. He thought she was in the bedroom. Now he's become the face of gender violence. And it's fine to say, protect yourself, don't look. Don't look. It's not possible. It's not possible in this age and era to miss the media. It is not possible to say, I'm never going to open the internet and see my face. I'm never going to open a newspaper. I'm never going to look at placards. I'm never going to watch TV. Constantly it reappears. You see gender violence, domestic violence, you see Oscar Pistorius. We had, not too long ago, threaten with an interdict, to stop a TV channel, to say, how can you do it? How can you use his face? This case has nothing to do with gender violence. But the penny doesn't drop, because some people don't want the penny to drop. It's not what they want. Ignore this court's finding, that's fine. Criticize this court, that's fine. Criticize him, that's fine. We want our perceptions. We say, my lady, that as a result of this sustained campaign of misinformation, the accused's reputation will never recover. And uninformed members of the public, or people who wish to remain uninformed in order to give preference to their own perceptions, have subjected the accused to public abuse and harassment. I told you about the incident. I mean, how silly is it not? He walks in a grocery store and he then gets, women start to scream, she's with a murderer in the shop. I mean, it tells me another woman came to him and said, just excuse her. I apologize for her conduct. But he's subjected to it. He cannot avoid it. We say, my lady, that these factors, in addition to what we've said, also constitute mitigation, but also should be taken into account in relation to compelling circumstances. Now, my lady, when I deal, and this is, in my view, the most important paragraph, is from paragraph 70. It's the reconciled facts between the findings of the trial court and the findings of the Supreme Court of Appeal. If I may fast forward, I'm coming back to it and ask you to go to page 38. Then you will see we deal with the appropriate sentence. And one thing we cannot do is to tell you what a sentence is. We just deal with the principles and then leave it in the hands of the court, what we should do. But, my lady, it is so important that when I deal with this reconciled facts, that we see what we must see. I was right in the beginning when I started to address you, I said there were 4 enemies. And it's that perception, this strong, world-class athlete shooting his girlfriend. And it's time, my lady, it's time for many reasons. For you would have known, you would have seen. But it's time to explain our address to you, to see what we should see. And for that reason, as Mrs. Steenkamp wanted photos, for that reason I want the accused to stand there, and when I address you on that, on his stumps, that we can have an idea of who the second Oscar was. Otherwise, it does not help. He would not be seen with that. So I ask permission that he could just come around, my lady, stand there when I point out certain things, that we have reality in this. And it's so important for our case and whatever may follow in this case, my lady. So I ask the court's permission to do this. Yes. Thank you. And I'm told he's very embarrassed, but he understands that it's important to do that. He's very, very embarrassed and ashamed, but it's time. You could just take off the legs then. If you can maybe just stand on my side where I can see him and then talk to him. A lady. We talk about the findings and great respect for the Appeal Court of Appeal's finding. I absolutely respect it. But we're dealing with sentence. We have to see rationality now in the context of sentence. And what we have, and these facts can be tested. Just hold on to this. These are the distilled facts that can be tested. Let's look at who is the person. After incorporating the Supreme Court of Appeal's finding that you must sentence today, or Friday, or whatever day, this is the person. It's 3 o'clock in the morning. It's dark. He's on his stumps. That's all common cause. Not on his legs. He's not running around the track. He suffers from an anxiety disorder. We know that the uncontested evidence was that when he was on his stumps, his balance was seriously compromised. And without anything, he would not be able to defend himself. He was anxious. He was frightened. That frightened finding is not gone. And he was suffering from an anxiety disorder. That's not gone. This must all be seen in the context of his disability and the pervasive effect of the disability on his subjective thinking. He proceeded to the entrance of the bathroom because of his excessive fight response and his inability to run away. My lady, all these facts are factual findings, not disturbed, and where the Supreme Court of Appeal made different findings, we included them here. He was armed with a heavy caliber firearm ready to fire. His perception that he and the deceased were in danger was fortified by the following. The open bathroom window, which explained the noise he had heard. So it's not that there was nothing. Of course there was. It's factual findings. The fact that there were ladders outside his house, as his house was being painted at the time, which would have facilitated access to the bathroom. He had heard the slamming of a door and subsequently saw that the toilet door was in fact closed. He believed that the person in the toilet was an intruder and that the deceased was at the time in the bedroom. He fired 4 shots into the toilet door with a downward trajectory, thereby not aiming at chest height. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational and therefore not genuine. And that's where I stop. When I look at him and I think, how rational can it be, my lady? And if he may go back. I see that it's stressful for him if he may go back. And that's the point, and that's the Ferreira's case where I'm at, my lady, where we get to this point. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational. For purpose of conviction, I accept that, my lady. I accept that. That's the Supreme Court's appeal finding. That's fine. It's on law principles. But what are we dealing with when we look at that rationality? We're dealing with a person that's not like me. It's not like her, it's not like her. It's a person where I don't want to overplay vulnerability. That's not what I want to do. I don't want to overplay disability, but the time has come that we must just look at different eyes, at least with unbiased eyes. It doesn't mean because he's vulnerable that he can do what he likes. That's not what we're saying. But we're saying we're entering the field of sentencing. Look at that man's conduct. Was his fear rational? No, it was found not to be rational. Meaning that he was entitled to shoot? No. That's why he's convicted of dolus eventualis. But please, let's understand. Let's understand when you combine these factors, you can't look at each one in isolation. Put them in one box and see who's this man that you must sentence. It's not the man running with evil on 2 healthy legs, wanting to protect his girlfriend and running to the bathroom to kill. That's not what it was. It's a compromised person. That's all. We say, my lady, the last finding was, in discharging the shot, he foresaw that he could kill the person behind the door, whom he perceived to be an intruder, and he reconciled him with that consequence. He gambled with the life of the person in the cubicle. That's the finding. We accept that. But we say, just look at the he. Factually, his conduct and state of mind can be distinguished in relation to moral blameworthiness and in the case of dolus eventualis from the conduct of the person with an able body who was not vulnerable as a result of a severe disability, whose subjective thinking had not been pervaded by his vulnerability, who did not suffer from an anxiety disorder, who during daytime thought an intruder had entered his house, who did not have an excessive flight as opposed to a flight response, who did not believe that his loved one was at the time in the bedroom, and he did not see an open window after hearing a noise resembling that window. Added to the above is the fact that the accused is a broken man who has increased post-traumatic stress, depression, anxiety, and vulnerability. And we don't have to be psychologists to see it, my lady. We don't have to. I don't think, with great respect, that any person could walk up straight after going through this process, this judicial process, where you go, where you portray it in public constantly, where you constantly in the media, you go to jail, you come out, it goes to the Supreme Court of Appeal, you come back, you again become subjected to the same process. That's the man, my lady. And of course we can argue it's because of your own doing, but that's on conviction. Let's look at the person and let's see what the system has done to him. I was thinking, my lady, but I'll come back to it. I heard when Mr. Hewitt was in the Supreme Court of Appeal, it was made clear you cannot hide behind your fame. My lord, my lady, he desperately does not want to hide behind fame. He just wants to be treated as a normal, ordinary citizen, not a well-known figure. He does not want fame to make him qualify for something better. He just wants to be treated like someone unknown, someone who has done wrong and must be punished. My lady, when we get to an appropriate sentence in the circumstances, the fact is, and for good reason, that sentencing is preeminently a matter for the discretion of the trial court. We refer to the cases. And we say that makes sense as it is this court that has not only considered the facts, but experienced the emotions of relevant parties, which are not properly captured in the transcript. You can read that transcript many times. You don't see what a trial court will see. I can read it. I don't see some of the things. You read a sentence, but you don't read the emotion in the sentence. And that is why the rule is so strong that it's for the court, the trial court, to say, because the court smells it, it sees it, observes it, feels it. It's there. And you form an opinion of who this person is, who's lying, why are they lying, and what emotions they're going through. You form an opinion of the tragic incident, the pain of the family. You all have that. And you put that all together in context. Paper cannot do that. Paper cannot capture that. You must experience, you must be part of that feeling. And we say that is why the rule of law is that sentencing is preeminently a matter for the discretion of the trial court. And it's, I've said it before, I'm so happy it's not me that must impose sentence, because it is so difficult. It is so difficult, but there are fortunately aids to assist, to say these are the rules, these are the factors. We submit, my lady, that the aggravating factors resulting from the finding of the SCA, that's paragraph 76, page 39, do not outweigh the reduced moral blameworthiness of the accused and the other mitigating factors. We've in fact pointed out that you have, as close as what can be to the letter, also consider those factors. It's not that you ignore those factors. We say that this honourable court should, as best as possible, endeavour to strike a balance between the new aggravating factors and the many, many mitigating factors. In so doing, the court should be mindful that in imposing the previous sentence, the trial court has to a large extent already considered the aggravating factors. The question this honourable court must decide is what sentence the court would have imposed on a finding of dolus eventualis. That's really the question. That finding must then be adjusted in the light of the accused's reduced moral blameworthiness in relation to the merits, the fact that the accused was in any event sentenced on the basis that his conduct bordered on dolus eventualis, the undisturbed mitigating factors in relation to the conviction, the undisturbed mitigating factors considered at the previous sentence, the new or subsequent mitigating factors available to this court. We say, in considering an appropriate sentence, regard must be had to the fact that South Africa is a vibrant constitutional democracy with a progressive system of corrections. And we say that punishment must have a rational purpose. And we refer you to the Mate case, where it says that it makes it clear that punishment must be rational. It's not, we know previously the first choice, the second choice, the last choice was send the man to jail in general. And the courts came out subsequently and said, but that should not be an approach. You should not say the man must go to jail. First look at all options. Find a rational purpose, and sometimes you cannot avoid imprisonment, but then you do it after considering the whole spectrum of the rationality of a sentence. I'm sorry about that, my lady. We say, consequently, our courts in fashioning a sentence with a rational...
Mr. Roux, just hold on. Okay, you may proceed.
Thank you, my lady. We say in paragraph 81, page 41, my lady, consequently, our court in fashioning a sentence with a rational purpose that is appropriate to the individual circumstances in a particular case have shown a predilection for the variety of different sentencing options at their disposal, rather than simply resorting to the traditional approach to impose direct imprisonment as an obvious and first choice of sentence. We say that same sentiment is expressed in Grobler. We refer you to Grobler's case. We refer you to the Sanei case, where the court emphasized that a broad scope of sentencing options must be considered, from which the most appropriate option must be selected. The court in that matter also emphasized that a tendency in the past to regard direct imprisonment in serious cases as the first, last, and only option was not valid anymore in an enlightened society, and that a mental shift was necessary to regard direct imprisonment as a sentence of last resort. The court in Sanei referred with approval to Siebert. It's there, my lady, saying exactly what it's saying. Then there's a Shariva case where the court warned to say a convicted person should not be visited with punishment to the point of being broken. And it goes on to deal about restorative forms of justice and looking at the interest of the society, the victim, and the community. Page 43 at paragraph 85. We respectfully submit that it's clear that punishment is not meant to break the offender, but it's meant to punish the offender and to protect society by providing the opportunity for the offender to be rehabilitated. And we say this was well understood by the trial court. We refer to the sentencing judgment and the record, where the trial court correctly found that excessively severe punishment might break the accused, and that the result might be opposite of what punishment set out to do, which was ultimately to rehabilitate the accused. That one paragraph in the court's previous sentencing, it encapsulates the correct approach to sentence. In paragraph 86, the accused does not fall in the category of offenders who again ought to be removed from society. The accused had already successfully completed all the necessary courses set out as rehabilitative benchmarks by the Department of Correctional Services during his imprisonment. His rehabilitation should not be in dispute. There is no purpose served, and we're dealing just with one aspect, and ultimately the sentence is in the discretion of this court. There are many factors. We're only dealing with rehabilitation, and we say about that there is no purpose served in rehabilitating one who has already been successfully rehabilitated. The accused would not have been released on correctional supervision if he posed a danger to society and was not rehabilitated, and it's in fact clear in the reports. The reports are before you, and you can see that. As his rehabilitation has been achieved, deterrence and retribution must be considered to deliberate whether any purpose will be served in that regard through incarceration. We say that the devastating consequences of his actions have clearly deterred the accused. It is clear from his evidence. His incarceration of 12 months served as further individual deterrence. The deterrence remained during his correctional supervision and stringent bail conditions. He cannot sensibly be deterred anymore, and deterrence has with respect reached a point of saturation. We say any general deterrent advantage has already been achieved. If a sentence is now imposed on the basis of further general deterrence, this will merely serve as a veil for retribution. And we refer in this regard to S.S. de Blanche, A Guide to Sentencing in South Africa, the second edition, where he very aptly deals with specifically this effect, and where it's clear that once deterrence has fulfilled its role, that it does not remain as a sentencing option in a particular case. We also respectfully refer to deterrence has already been achieved. Professor Scholes testified that the accused's risk for non-violent reoffending was found to be low. That's also relevant to rehabilitation. Sending the accused back to jail would only serve to break him and to satisfy the consideration of retribution. So we must see if retribution is so important in this case. Our courts, we say in paragraph 92 on page 45, have moved away from retribution as a primary purpose of sentence, making it clear that retribution should yield ground to aspects of prevention and correction. This also seems to be the approach by the Department of Correctional Services, which on a daily basis experiences the negative effects of imprisonment. There was a media statement in 2014, and I'm not going to read it, but what they say, it was the Minister Ndebele says, inter alia, across the world, retribution for imprisonment has not yielded the results of deterring crime. Since retribution is narrowly focused on moral reprobation or outrage against criminal conduct, it fails to adequately reform offending behavior and to repair harm experienced by victims of crime. And it goes on, the full article is also available to you. At page 46, paragraph 93, we say that the shift from retribution to prevention and correction is also reflected in our case law. We refer you to the Matewane case, and we say that that's quite a long time ago that shift has happened. In paragraph 94, we say that we respectfully submit that the public interest would be rationally served, in this case by considering a sentence that incorporates community service, where the accused gives back to the community whilst not being a burden on the state or taxpayer. This is also consistent with Ubuntu. We again refer to the Ubuntu principle. It's well known to the court. And we say ultimately, my lady, that we tried to reconcile all the facts and all the principles applicable. And then the very difficult task would, of course, remain with this court to decide what's an appropriate sentence. I do not know. I simply do not know. It's for the court's consideration, but we have put before you what we believe are all the distilled facts, where we reconcile the facts of your findings with the findings of the Supreme Court of Appeal, to point out to you that we have not since moved to an evil-minded person wanting to kill his girlfriend. That's not the process. The shift is in fact very limited. Very, very limited. And it's for the court to decide how to approach that limited shift and what to do about it, taking into account this man has served a jail sentence. And then with that in mind, to impose an appropriate sentence. I don't know if there's anything else.